Welcome everyone to FRAND Council's webinar, Licensing Negotiation Groups. What, why, how? My name is Claudia Tapia. I'm the president of FRAND Council, and I will be your host today. As you may know, FRAND Council is a non-for-profit research organization focused on the link between intellectual property and innovation. To identify the most relevant topics and produce empirical research, we work closely with a wide variety of academics, experts, IP organizations, and stakeholders. On our website, you can find a range of free materials, studies, guidelines, summaries of relevant papers, and recording of our webinars, like this one. Moreover, we produce easy-to-digest content, specially tailored to non-IP experts, SMEs, and startups. This is free of charge too. Some examples are interactive graphics and interviews to inspire them. With this, we aim to assist innovative startups and SMEs to learn how to use IP to grow the businesses. As you know, more and more things are increasingly getting connected thanks to the Internet of Things. And to achieve that, standardization and standardized technologies are needed, and they are often protected by patents. And this is why we have created a case law area with summaries of 4 cases regarding standard essential patents and what is needed in negotiation between good faith parties, or parties acting in good faith. And this section is now also available in Chinese and in Japanese. And we have also a dedicated section in Chinese of IP relevant material that has been recently added. Without further delay, please allow me to introduce you our great speakers, Tsilikas and Dr. Igor Nikolic. Tsilikas is Senior Associate at the Office of Elisabeth Opie in Munich. He is PhD candidate at Max Planck Institute and an Edison Fellow at the Center for the Protection of Intellectual Property at the George Mason University. Welcome, Harris. Dr. Igor Nikolic is Research Fellow at the European University Institute. He has also a PhD from the University College of London. And he has recently published a book called Licensing Standard Essential Patents, FRAND, and the Internet of Things. Congratulations, by the way, and very welcome to our webinar. We are delighted to have you here. And maybe before we start, a final remark for the audience. Please do not hesitate to use the Q&A tool to submit your live questions. We have received already some in between that we will start using for the webinar, but we will pay attention to everything that you write so that we can address them in this webinar. You find it in the lower part of the screen. So you can raise your questions anytime during and after the presentation, and those questions will be addressed following the presentation. So, Igor, we are really looking forward to hearing what you have to say. So the floor is all yours.
Thank you, Claudia, for this great introduction. So I'm going to talk just briefly before we go to the Q&A discussion. So I'm going to explain a bit of the background of what we are talking about and also introduce the licensing negotiation groups. What are they? Why should we have them, and how would they work? So as a start, prominent technological standards like what we're talking about, like 5G, 4G, Wi-Fi, they consist of many patented innovative technologies contributed by companies. Now, these technologies, they're available on fair, reasonable, and non-discriminatory terms and conditions. On the one hand, the FRAND commitment ensures that implementers companies using the 5G, 4G would have access to the standard, but also they ensure that innovation incentives of SAP owners are protected and ensures wider participation in the standardization environment. Now, what we are seeing now is rise of Internet of Things, meaning that many different objects are getting internet connectivity, from cars, domestic appliances, utilities, healthcare devices. And this gives significant welfare gains for consumers, businesses, societies. But sometimes there are also disputes about precise licensing terms for standard essential patents. And here is a brief chronology about what the European Commission has been doing in this area. So in 2017, the Commission published communication setting the EU approach for standard essential patents. And it emphasized the need for having increased transparency on the number of, for example, truly essential patents, to have better patent declarations, on efficiency of SAP licensing, for example, by having more patent pools or having some kind of licensing platforms, and providing some clarity in FRAND licensing negotiations. In 2020, the IP action plan is published, and Commission reiterated that it wants to work on enhancing the transparency and predictability of licensing SAPs. And this year, the Commission's expert group on standard essential patents published its report, which contains 79 proposals how it may reform or change FRAND licensing framework. And this is the proposal 75, where they considered the possibility of introducing licensing negotiation groups, which we will talk in today's seminar. So first, to discuss what are licensing negotiation groups. So currently, how the industry operates, it's in Europe, it's by bilateral licensing. That means that SAP owners identify companies that are using their technology, they approach with negotiations, and they negotiate within the framework of Huawei versus ET by the Court of Justice of the European Union. The licenses need to be FRAND, and the LNG and their advocates, they say the suggestion is to have all the implementers or majority of implementers in one industry together in group to collectively negotiate with SAP owners. The idea is that these licensing negotiation groups would observe Huawei versus ET framework. There will be safeguards to prevent licenses from delays or holding out conclusion of licenses, and they will be monitored by competition authorities to avoid collusion. Recently, digicomp in the consultation on horizontal cooperation guidelines, they examined how LNGs could work. They have assessed them as a joint purchasing arrangements and considered their potential competitive impact. Also, in Japan, they're exploring how and in what way LNGs may be used and how to make them compliant with competition law. Why would we have LNGs? So what's the benefit? So the idea is, the argument goes that it would help efficiency in licensing negotiations. So instead of negotiating with many individual companies, especially in the IoT, where there will be many implementers from diverse industries, it will be more efficient to aggregate them at one point. So licensing could be done at one or at least less points and cover as many implementers as possible. From the implementer side, it is beneficial because they could pool technical and commercial expertise, and this is said to provide a balance in the licensing negotiation, and would be especially good for SMEs who may not have the knowledge or experience or funds to negotiate on the equal footing with SAP owners. And how would LNGs look like? Well, we don't really know at this moment. We only have proposal 75 of the Commission's Standard and Structural Patent Expert Group, where they provide their own kind of views, proposals, how they may operate in practice. So the idea is to have licensees active in the same market, that is competitors, come together in presumably one licensing negotiation groups, which would collectively negotiate on behalf of their members. But before that, the proposal envisages that licensees would have to agree on the licensed product to be covered, on the value chain in the licensing, and on the maximum amount of royalty they would be willing to accept. Only then would the negotiation group come and negotiate with SAP owners. And aware that these proposals may trigger competition law suspicion, the report envisages competition authorities monitoring the formation and also operation of licensing negotiation groups. So finally, and just a brief overview, what are possible competition concerns that we have about this way envisaged licensing negotiation groups? So the first issue is that licensing negotiation groups would cover licensees operating in the same market, that is to say competitors. So we need to be very careful how much competitors do we want to gather in the licensing negotiation group. So on the one hand, there is a paradox in my view. So if you want to have more transaction cost savings, or to cover, we would want to have as many competitors as possible, the broadest market inclusion in the licensing negotiation group. But then from the competition law side, if you have so many competitors or the whole industry in one LNG, that opens up increased buyer power, or even approaching monopsony buyer power. So this is not something that competition law allows. Then the second issue is that the proposal envisages setting up by the implementers a maximum amount of royalty they would be willing to pay, and then negotiate with SAP owners. And the practical side is, besides this may be actually price fixing, which may be anti-competitive by object, it is also a question then what is there to negotiate if the maximum price by the implementers is lower than the price that SAP owners would accept? And also, does this price comply with FRAND licensing principles? So these are just a preview of questions that we will discuss. And now I would turn to Claudia and to audience for discussion.
Thank you so much, Igor, for this interesting introduction of the topic. And as I said before, we have received some questions already. And thank you to all of you who have been participating and sending us emails with some questions you wanted to deal with. And I would like to start with those. But of course, I will keep looking at the Q&A parts. So if you have questions, don't hesitate to raise them. And the first question we received is, what are the competition law challenges of LNGs? I'm not sure who of you wants to start. Harry, since you haven't been presenting, would you like to start with that one?
Yes, and I will, thank you very much, Claudia, and I will pick up from where Igor left us basically in his very nice presentation. I would say the main concern is that the proposal for LNGs, as is currently advanced, provides for competitors to join in groups, and these groups to negotiate licenses, and based on a fixed upper bound for the royalty rate. So this is, in competition law terms, price fixing, basically. So the main competition concern with LNGs is that they are engaging in anti-competitive price fixing. A further issue, as also Igor mentioned earlier, is whether the participants in an LNG possess collectively market power to suppress the FRAND, the royalty rate below the FRAND level. And this can have many negative consequences on competition. Mainly, it can diminish incentives for participants in SDOs to contribute technologies to standards. So the main competition harm we have in this way is that all the consumers would be willing to pay for high quality standards. These standards will not be provided because the price of technologies is suppressed by LNGs. So this would be an outline, a brief outline of the main competition concern, I'm saying.
And
if I may add a bit, yes, please.
If I may add to complement Harris, so I think when we talk about LNGs, it is important to distinguish between the proposal of the SAP expert group, and which is one thing, and talking about some kind of collective aggregation of implementers on the other. So when you talk about the proposal of LNGs by the expert group, so it explicitly provides some kind of some solutions that, as Harris mentioned, directly lead to collusion and price fixing. So agreeing on the maximum acceptable royalty, licensing level, license product, that all in practical operation, that leaves the question of what is left to negotiate if you agree among yourselves, everything, and then approach SAP owners. It really leads to price fixing cartel. So that's one issue. And other issue we can discuss if and how some kind of collective may be used that is not against competition law. And again, I want to reiterate this principle, which wasn't explained in the report, but is in inherent tension. So the aim from the SAP expert group is to have as many competitors together in LNG to reduce transaction cost. But if the royalty of that LNG is in so anti-competitively low, it would not be, how to say, it would still be anti-competitive and low enough to disincentivize further innovation of SAP owners, and if it's below FRAND royalty level, then it will be of no use. So if we aggregate as many companies to create monopoly power, I don't think that would be a good way, a good solution. So there is a tension between, on the one hand, reducing transaction costs and then creating monopoly power.
To that point, because you both are talking about these antitrust risks, and someone is raising here the point: which are the differences between these and patent pools? Because they say, okay, if LNGs are potentially anti-competitive, why are patent pools not? Since they effectively fix a lower bound of the royalty rate. So I see Harris thinking on this. Would you like to start sharing your thoughts on this?
Yeah. In fact, patent pools that combine alternative technologies, so competing technologies, are in fact illegal under competition law. So, for instance, the European Commission has provided guidance in its guidelines on technology transfer agreements, where it is clearly stated that patent pools must ensure through rigorous essentiality checks that only complementary patents and technologies are included. This is exactly to avoid a situation where competitors join in a patent pool, and then the patent pool really operating as a cover for a price-fixing cartel between sellers. So indeed, there is a correspondence between LNGs and patent pools, but with patent pools that are in fact anti-competitive. So there is a correspondence indeed, because LNGs are also to be formed by competitors. And so this begs the question whether, since patent pools that are integrating competing technologies are illegal, shouldn't be the same for LNGs, since they are groups of competitors. So they are just price fixing, but only on the buying side, on the licensee side. of the transaction.
Igor, I'm not sure if you have anything to add. Otherwise, we can go to the next question.
No, I agree with Carrie. So the difference is that on the licensee, on the LNGs, we have aggregation of competitors. But in patent pools, we have aggregation of complementors. And actually, when you aggregate complementary patents, you may get lower price for patents than if you go to each and every SAP owner. But if you aggregate competitors, then you may get higher prices. And actually, as Harris mentioned, guidelines by the European Commission and in the US, they look unfavorably to patent pools of substitute technology, that is, to patent pools that aggregate competing technologies. So that's the main difference.
Thanks a lot for the clarification. Maybe we go to the next one that we received, and then I keep looking at I'm trying to combine both. So the next one will be, could LNGs generate efficiencies in FRAND negotiation, for example, reduce transaction cost? So who would like to take this? Maybe Igor, would you like to start this time?
Yes,
yes,
I could try. So I was thinking a lot about this proposal was about LNGs. So the idea to reduce transaction cost in the IoT, where we would have a lot of small companies, is a good one. I think discussing the ways to achieve it is a good discussion. But again, as I mentioned previously, we may need to distinguish between the proposal of the SAP expert group and general some kind of aggregation. So these LNGs, as proposed, I'm not sure they would generate efficiency already what we talked about, because it's price fixing, it's aggregating competitors, it's creating market power. But if we could envisage some kind of LNG that doesn't discuss prices or doesn't achieve to fix prices, and is mindful of Commission guidelines for a joint purchasing agreement, which provides a safe harbor that competitors may join joint purchasing organization if their combined market share is less than 15%. In the US is less than 20%. So there are guidelines already to have small companies joining in some kind of group purchasing organizations. So if we are mindful of these market share thresholds, that only applies to small companies, and there is no discussion of the licensing terms, there is no exchange of sensitive commercial information. Because one argument that I missed about previously, so if companies need to agree on the maximum licensing royalty they would accept, to arrive to that, they need to exchange sensitive commercial information about what's the cost of IP they're already having, what are their production costs, what are their production plans, how many units are they producing, which is all sensitive commercial information to obtain in order to arrive to this maximum royalty. So in this kind of ideal LNGs, we don't want that. So in my view, it could work only if it combines maybe SMEs and without discussion of prices. So that's my view. Maybe Harris can complement.
One comment I would have based on your very last sentence is that as the proposal is currently advanced, it appears that the very purpose is to discuss prices. So again, if we go to the expert group proposal 75, which is the most thorough examination of this concept so far, they explicitly mention that the LNGs will discuss on an upper bound for the license royalty rate. So one issue is that whether LNGs have as their very object to fix somehow the price, the royalty rate. I would also add two additional considerations to what Igor just said. One thing is the concept of efficiencies under European competition law. So both under the treaty, Article 101, paragraph 3, but also based on the case law of the Court of Justice, under EU competition law, only those advantages that are objective and do not result from elimination of competition can be considered pro-competitive efficiencies. So if you have a cartel, for instance, that minimizes transaction costs because you have to transact with an association of sellers, this is a reduction in transaction cost, but it results from a clearly anti-competitive arrangement. This is not something in the US. They use the term cognizable efficiency, so something that can be recognized under antitrust law. So I'm not sure that LNGs can produce this kind of efficiencies, the pro-competitive kind of efficiencies, the objective advantages that we seek when we discuss about licensing. And the second consideration, I would go back to the very first slide that Igor presented about the international standards ecosystem. So what we have seen is a system that is very successful. In the past 10 years, we have seen markets with amazing growth in every important competitive aspect, in price, in quality, in innovation. So the market has proven that it can provide a good solution that is very responsive to challenges when it comes, for instance, to transaction costs. We have seen many pools being formed. We have seen licensing platforms being formed to facilitate licensing with SMEs, to facilitate the uptake of the Internet of Things. So we have a very responsive market, and it's not clear what LNGs would add in terms of efficiencies.
Thanks, Harris. I'm going to take now one question from the Q&A that we received right now, which is, what is the role for national standard bodies with regard to LNGs, if any? So maybe I repeat it just in case. What is the role of national standard bodies with regard to LNGs, if any?
May I venture with an initial remark and then Igor can
Please, go ahead.
So I think we should consider this question from the perspective of what standards development organizations are. They are technical bodies that they organize technical cooperation to produce international standards. So they are not commercial bodies that are facilitating licensing or that they are engaging in commercial discussions. So if we were to consider that SDOs would facilitate somehow LNGs, this would imply a major shift in their role as technical bodies and not commercial bodies. So this would be an initial thought on that.
Yes, now I had a time to think about the question. I think with LNGs, the main question is competition law question. So as Harry said, standard bodies, their task is to develop standards. They include engineers, and I don't see actually them getting involved into this sensitive price discussions. I don't think the national standardization bodies are appropriate. They have the appropriate role, but where I think they may contribute is kind of providing to SMEs the knowledge, making a transparency about SAP licensing framework, about FRAND framework, about who to contact for license, the existence of patent pools, patent pool licensing, who are the main SAP owners. So I think standardization bodies may be one additional vehicle which will kind of increase transparency to the SMEs about SAP licensing market.
Okay, thank you. And maybe I'm taking the next one of the list that we received, which I believe, let's see if it appears in the, yes. If LNGs raise competition problems, do they constitute restrictions by object or effect? And maybe if for those who are not antitrust lawyers in the audience, you could explain a bit this difference and then let us know why is this important.
Sure. So this distinction between restriction by object and effect is found in the treaties in Article 101 of the TFEU, where it is stated that an agreement or a practice can be restrictive by object or effect. And based on the case law of the Court of Justice, agreements that have a clearly negative impact without any possible pro-competitive efficiencies are considered to be by object restrictive. So their very object, their very purpose is anti-competitive, to restrict competition, and they have no plausible pro-competitive justification. To say it in more technical terms or in more simple terms, there are agreements that have a clearly negative impact on competition.
Thank you.
And
if it's okay, we can, unless you, Igor, do you have anything to add?
but nothing, just to answer the question though, in my view, again, the proposal as I currently see it represents restriction of competition by object because it clearly involves exchange of sensitive business information, price fixing. But even if it's not, for some reason, we already discussed there are negative anti-competitive effects. So suppression of licensing prices, what incentives to innovate will it create, and how it will work in practice. So again, if there is a maximum level that LNG will accept and the minimum level that SAP owners accept are not correlated, then what will happen? Breakout of negotiations and maybe individual negotiations. But then this price that was already agreed with LNG, why would then implementers agree to pay higher price outside of the LNG? Probably they would still stick to it. So we would see kind of market coordination on this agreed price. So I don't think this is actually a good way to go.
May I add in again two considerations to what Igor very nicely presented again. I think to discuss LNGs and their whether they should classify as a restriction by object or effect, I think two issues should be a priority focus. First, whether they involve pricing discussions and exchange of sensitive information, as Igor just said, because these two practices very rarely have a pro-competitive impact. And the second is whether the LNG can lay a plausible claim to a pro-competitive justification. I think on both these counts, I would agree with Igor's conclusion that as the concept is now advanced, it looks more like a restriction by object rather than effect.
Thank you. Thanks for clarifying. I have kind of several questions that I feel they are related, so I'm gonna kind of try to bring them all together. So on the one hand, we have some people saying, or someone's asking, how can the competition concerns be addressed in LNGs, while others, or at least a couple are saying, do we need LNGs? And if we are not needing them, what can we do to achieve the transparency and predictability that the Commission advocates for? A Vanchi solution. So I bring everything to you, and then just let me know what you think about all these questions. Who would like to start?
What was the first one, Claudia, please? Can you remind me?
Well, the first one is, how can the competition concerns be addressed in LNGs? The second, we need them at all.
I think, yeah, I was thinking a lot, how can competition law concerns be addressed in LNGs? And kind of my vision is actually, this is my own opinion, is we need to maybe clearly stick with the guidelines that we already have. And they say, first, be mindful of the market power. So getting the whole industry, every competitor in one sector together, this is clearly not acceptable from competition law. So only maybe small and medium-sized entities may join such kind of groups. And second, I don't think there should be any exchange of sensitive commercial information. I believe that if we have small and medium-sized entities which are less than 50% of the market coming into organization, they may achieve a quantitative discount. What I'm thinking about, all big patent pools have public royalty rates, and patent pools and SCP owners often give quantitative discounts. So how many units you produce, the more you produce, you pay less royalty. And that way, effectively, companies, big, large companies, may pay lower royalty than small and medium-sized companies that have lower production value. And if they join some kind of, I call them license purchasing group, which is there only to help SMEs achieve this quantitative discount, maybe that would be a role but then we would not call them LNGs, we would call them something different. And I call them licensing purchasing group to denote that they're purchasing licenses that are already publicly available and not negotiating and renegotiating and price fixing among themselves.
May I also offer a brief response? I think you asked two questions. First, whether something could be done from a competition perspective for LNGs, and second, whether do we need them at all. I think the second question is the important here, because the answer to this question also gives us an answer to the first question about the competition, the role of competition law in this case. So I think this is the major problem. It's not clear why we need LNGs in the first place. If we have markets that have proved in practice that are very successful, very responsive, that enable the implementation of standards in an unprecedented scale. So we have, for instance, in the smartphone industry, we see how this industry exploded in 10 years. And basically everybody in the world right now has a very high-tech smartphone that enables so many functionalities. So we have seen that even when thousands of patents are involved, markets have provided solutions for these patents to be accessed by those using the standards on FRAND terms. And in addition, even when we have disputes, which inevitably will arise on what terms are FRAND, because we are discussing about very sophisticated, very complex technologies. We have competent courts, for instance, in Europe, we have the Court of Justice of the EU providing guidance in its 2015 decision in Huawei versus ZTE, and we have a very large number of cases by national courts in Europe providing very detailed guidance to parties, how to negotiate license and what terms can be considered FRAND, what kind of behavior can be considered FRAND. So again, this is the main problem. How do LNGs contribute to the good operation of the markets? What do they provide? Because if they don't provide something, then it goes to the other question. What is the pro-competitive rationale of LNGs? Because if there is none, then we go back to the previous question, whether this is a restriction by object or effect, if there is no positive purpose served here.
Thank you. And maybe to the other comments on how to achieve transparency and predictability. Do you feel that with the guidelines is sufficient information for companies to know? And in particular, I see that, for example, Igor is keeping in mind those companies that they don't have the resources to maybe understand what FRAND is, or they need more support or have some support, and that's why you were thinking that maybe some kind of similar idea for SMEs could be manageable for this market. But I wonder, what's your opinion also, Harris, on this proposal? Because this is kind of, I think I have never seen or read about it. Probably you're gonna write about it, Igor. But have you also have thoughts of things that can be done to improve this aim. And then Igor, I will come back to you in case that you have other thoughts to share.
I think here we are discussing about two goals. One is to have a transparent system for standards development and licensing of essential patents. This is one goal. And the second is to facilitate SMEs to participate in these markets. And we need that because the SMEs are the engine of economic growth, both in Europe and the US and in many other jurisdictions. So it is a legitimate goal for a policymaker to incentivize SMEs to participate in standardization. One concern that I always had is that these two goals are not always compatible with one another, because if you increase the transparency and reporting obligations for participation in standards development, I'm not so sure that many SMEs have the resources to meet these transparency obligations. So we have here, I mean, with transparency, a double-edged sword. It can be both positive, but also negative at the same time. So it can provide assurance to companies to participate because they know they have better information, but they also impose burdens. So it's not. I cannot offer a clear response here. Maybe Igor can offer something better.
So are we discussing about SMEs, or what was the question?
SMEs, transparency. I'm mixing everything to confuse you. No, but I think that we have all these ideas coming here. That's why LNGs seemed for some very attractive when they heard it for the first time, and that's why for me it's important to understand. Okay, if LNGs is not the solution according to your opinion, what do you think can provide this predictability, and how can we help to those SMEs in this scenario? And so that's more or less the idea.
Yes. Well, I think that already we do have transparency, at least with licensing terms. So for SAPs, there are patent pools, many of them for many different standards. The largest, if we talk about 4G and 5G, the one big patent pool, Avanti, is already there. For one industry, car sector, it will go for other industries as well. The largest, there are many studies out there that try to rank who are the largest SAP owners. So they're kind of known. So I think we have enough of transparency, and all the patent pools and SAP owners have publicly stated their rates. So I think any company that does a bit of due diligence would know what's kind of the state of the market. So in my view, there is transparency. So the only question is how to make it more efficient. So how companies would negotiate more efficiently for license, how to avoid holdout. So those are the questions. And LNG is trying maybe to answer that, but I think it answers it the wrong way. So I don't really see a room, at least how they are now envisaged to, I don't think they would add anything beneficial to already transparent market.
Okay. I see here also in the Q&A, there was this thought or this scenario that they were raising. Supposedly that a European government mandates the use of a particular standard, and will LNGs facilitate compliance with regulatory requirements? I'm not sure if you need more information, maybe from the question, that someone elaborates it. I'm still trying to see. Yes, so the person who raised this question, it would be really good if you could elaborate a bit on because for me it's also a bit confusing how this will be the link, and then we will raise it again. And maybe we can take in the meantime a question from the list, which is, what's the difference between LNGs and group purchasing organizations in the US and in the EU? So don't know who wants to start. Igor, would you like to start?
Yeah, I can start. So in my view, there are two big differences between LNGs and group purchasing organizations. So first, what are group purchasing organizations? They are joint purchasing agreements by many small individual companies in order to achieve better terms, some quantitative discounts for suppliers. And some may say it's the same as LNGs, but it is not. So as we've seen in the proposal for LNGs, they are there actually fixing the price among them in the LNG and renegotiating the price with SAP owners, which we don't have with group purchasing organizations. But there are also two very important factors that distinguish the two. One, I think, is group purchasing organizations. Therefore, for tangible goods, physical products, and LNGs relate to intangibles, to patents. And this is a big distinction, because for physical goods, you do not use the physical good until you pay the price and agree on the price. And then you may talk about the quality of the product, quantities, different characteristics, what kind of discounts would you have. And then when you pay the price, you obtain the product. And with SAPs, it is a bit different. So once a standard is released, it is publicly known. And the implementers, usually how it works, licensing occurs ex post. So companies start implementing 5G, 4G products, and only later start negotiating the price for the SAPs, while at the same time, they're using the technology. So that's a disbalance. And SAP owner cannot physically prevent companies from using the technology. It would have to first to go to court, sue for patent infringement, prevails in patent litigation, ask for injunction, and then, but it cannot get an injunction because of Huawei versus ZTE framework unless it has offered a FRAND license. So it is not comparable to physical products where the seller can just withhold the products and prevent anybody from using its products until the price is paid. And the second big distinction is that SAP owners need to license SAPs on FRAND terms. So in group purchasing organization, purchasers are free to decide if they want to sell their physical product. And if they are going to sell, what's the price? They're not constrained by anything. And with SAPs, we have different picture. So SAP owner must offer licenses to companies at certain level of the production chain. And it is also constrained by the level it can charge. So the level must be FRAND. So there is these two distinctions, I think, make LNGs not comparable to group purchasing organizations in the US and the EU.
Thank you. Hart, do you have anything to add, or should we move to the next one?
No, just that the 2 points, Igor made 2 excellent points. I think this is something that should be considered by those discussing the LNG concept. One issue that I would like to note is that the European Commission, in its recent consultation on the revision of the horizontal guidelines, appear to treat LNGs very similarly to joint purchasing arrangements. And as Igor mentioned, there are clear differences between the two concepts. And also a third, I would add, and practical aspect is that joint purchasing arrangements typically involve very small entities that have basically no control over the price of the goods. So they have no monopoly power, basically. While with LNGs, we see that the concept is advanced by some stakeholders that we would not think of as SMEs, small companies, or anything like that. And for instance, we see the automotive sector pushing for this concept, and one could say that if these companies were to join together, they would have control over the price of the license. So this is a big difference between the two also.
Thanks to both. I'm gonna pick up this time one of the Q&A we're receiving, because we're receiving a lot of messages. But here it says, do you think that the risks of litigation in case of LNGs are similar to those arising in case of bilateral FRAND negotiation? Or perhaps could the risk be even higher in the case of LNGs frameworks? Who wants to take that?
I will give a very short answer because it would be even higher, because we have already discussed for quite a while the potential negative competitive effects of LNGs, all of which are actionable in court in both the EU and the US. So it's not hard to imagine that some licensors would like to challenge these arrangements in court, so that courts or competition authorities could review these arrangements and make a decision on whether they are competitive or anti-competitive.
Let's pick up this time one of the list, shall we? Are LNGs useful for licensing of IP rights like GPOs or for the purchase of physical products? So with GPOs, I assume it's group purchasing organizations. Who wants to take that?
Yes, well, I already said my opinion that purchasing IP or licensing IP rights is different than a purchase of physical product. So with the physical product, you can negotiate on if you want it, do you want how much quantity, how much quality of different product, but with patents is different. If you have truly essential patent, you either use it or not. So there is no discussion on the quality of do you want a patent, do you not want a patent? You must license if you infringe. And as you say, there already exists FRAND commitment, and FRAND commitment should ensure that the licensees get fair, reasonable, and non-discriminatory terms. And we have seen in court cases that you can enforce that commitment, you can litigate, and in the final instance, court may decide on what FRAND is. So I'm not sure that they would be comparable, the license negotiation groups would be comparable to group purchasing organizations for physical products.
Okay, I'm gonna, since I just seen that we received a clarification of the previous question that it was, we didn't really know what it meant. So here it goes. National standard bodies' involvement in FRAND LNG's discussions and the role for them. The role they are foreseen to play in Europe economies is codifying requirements on products legal to place on the market in those European economies. European level cooperation exists to ensure this does not result on non-tarifary barriers to trade, among other things. Harris, I see you knocking.
Yes, because I agree. This is true that with standards we reduce trade barriers under certain circumstances. But what I don't clearly see is how LNGs could facilitate the uptake of these standards, since, as Igor mentioned, basically you don't need a license to practice a standard. Although I have to say that there have been decisions by several German courts stating that the standard user has a duty of due diligence prior the implementation of the standard. So it's not clear why LNGs would actually enable more companies to practice standards, since they are free to practice them even now and even without a license, basically.
And the same person wrote that even going beyond LNGs, you could easily see national standard bodies playing a role in, for example, requiring standardized features to not require licenses at all. in order not to make compliance with a standard subject to legal uncertainty with licensing negotiations, for instance. Any thoughts on this?
One thought is whether this again goes beyond the nature of SDOs as technical bodies that normally do not undertake commercial license negotiations, or they don't play a role in these. And the second is that if SDOs require that basically all technologies contributed to standards are given for free, whether this would limit participation in these SDOs, especially by those entities and companies that rely on licensing revenue to finance their research and development and their participation in standards development. So I think these two issues are problematic at first sight with this proposal.
And I'm getting a, but this time you need to be really short on this, because I have one of the many questions is looking at the top-down aggregate analysis and whether that will help in this using it as a basis for the negotiation of patent holders. Any thoughts on this?
Yeah, can you repeat the question, please?
Yes, here it says, instead of discussing prices and an upper bound, could LNG make a determination of the royalty rates based on a top-down aggregate analysis and use this as the basis for the negotiation with patent holders? So, Paris, I see you smiling. Do you want to start? But then, guys, you need to be very, very fast. We'll literally give you 1 minute.
First, to me, this seems more like price fixing than the original proposal 75 that we have discussed so far, because their licensees would actually arrive at a specific price. So this is price fixing, the definition, I would say. And second, I have some reservations on whether top-down methodologies are really the best way to calculate royalty rates for licenses of essential patents, especially where we have portfolios with many patents.
Igor, your 30 seconds.
To me, this also sounds a methodology for price fixing. So instead of directly negotiating, you then use you try justify it by applying top-down approach. But one problem with top-down approach is, how do you know what's the aggregate royalty and who is the one who decides it? So is it implementers, is it judges, or is it the industry? Nobody actually decided this aggregate royalty. So again, we're just kicking the ball to somebody else. So I'm not sure this will, it's the same as directly price fixing.
Well, thank you so much for sharing. As you've seen, this is a super interesting topic. I keep receiving questions all the time. In addition to that, I apologize to those who didn't get the chance to raise the questions, but the time was reduced. I would like to thank both the speakers, and by the way, congratulate you for not only the book, but also the forthcoming papers that we are going to see, if I understand it correctly, in a couple of weeks. Is that correct? Yes,
Yes.
And as explained before, a recording of the presentation will be made available on FRAND Council's website tomorrow. So please don't forget to register for the upcoming webinar, which you can see here on the screen, Intellectual Property Systems in China and Europe. It's a joint webinar in China with China IP Help Desk, with Peter Finney and Simon Chitham as speakers. So please participate and keep sending us questions. We really enjoy having this kind of discussions with you, and see you hopefully in the next webinar, the latest. Thank you very much. Bye-bye.
Thank you.
Thank you very much.